And members, our last bill is Chair Dean's House File 213. And we have a testifier from the Hennepin County Attorney's Office, Dave Brown, if you can come forward, sir. And Representative Dean then moves that House File 2013 be laid over for possible inclusion on the omnibus bill. Representative Dean, your bill is before us.
Thank you, Mr. Chair, and committee members and members of the public. This bill is, I think, long overdue. We know that in the past, Minnesota had decriminalized small quantities of marijuana. But at the same time, there were quantities that, when you were above that, the penalties were fairly significant. And of course, repeat offenders would also have some issues regarding relative to the quantities. So this, this bill takes a look at those quantities of cannabis or marijuana, and it changes the levels for sale, and it changes the levels for possession. I think if you look at your House File summary, you can see the controlled substance crime in number 3, which it sort of mixes possession and sale. I'd like to try to break those apart so members can digest them a little bit. Sale of 5 grams or less would still be maintained as a petty misdemeanor. More than 5 grams, but not more than 10 grams would be a misdemeanor. More than 10 grams, but not more than 42.5 grams would be a gross misdemeanor. And more than 42.5 grams would still be a felony. When it comes to possession, 42.5 grams or less would be a petty misdemeanor. More than 42.5 grams, but no more than 100 grams would be a misdemeanor. More than 100 grams, but no more than 250 grams would be a gross misdemeanor, and greater than 250 grams would still be maintained in a felony. And for those who aren't the best at international measurements, 42 grams is roughly 1.5 ounces. So this bill would put it in statute, would define these, and I think go a long ways to undoing some of the harm that's been done over the past 30 to 40 years on the war on drugs. So that's the bill, Mr. Chair, and I'll turn it over to the testifier.
Very well, thank you, Representative Dean. Mr. Brown, welcome to the committee.
Mr. Chair, members, thank you so much. I'm David Brown. I'm the Chief Deputy Hennepin County Attorney. Want to thank Representative Dean for bringing this bill forward. Our office supports graduated penalties for the possession and sale of marijuana. The County Attorneys Association supports the idea of graduated penalties. While I don't think we've had input from all the stakeholders, law enforcement, medical community as to what those numbers should be, I think the numbers that are presented in this bill are an excellent starting point for that conversation, and we want to be part of that. We have a group of county attorneys getting together in the near future to talk about that, see where we're at with that. In terms of our office, the reason we're so supportive of this is that we have exercised our discretion to provide for some of this relief, where we will agree to give pre-charge diversion for possession of up to 100 grams of marijuana, where we will offer statutory stays of adjudication under Minnesota Statute 152.18 if they're not eligible for our diversion program. We will offer a gross misdemeanor for possessions for people that aren't eligible for diversion. So we have taken some of those steps in our office, but of course that's just our office, and that's not uniform statewide, and that's asking prosecutors to exercise their discretion, which we're happy to do. But I think this is a conversation where you have possession right now of under 42.5 grams being a petty misdemeanor, and for any amount over that, it goes immediately to a felony. And sale of any amount of leaf marijuana is a felony. that doesn't reflect what we need to be doing. And we want the input from law enforcement, from our community stakeholders, from other prosecutors in setting those amounts. And I think there are some other issues to be raised. Resins. People talk about resinous marijuana, but it's hard for the BCA to actually quantify that as a resin when we're dealing with oils and waxes and candies. And we support graduated penalties for those as well, but it needs a careful discussion about what those amounts are going to be. Typically in our office, for those waxes, we won't charge the felony until we have 42.5 grams of that. But again, or 85 or so dosage units, but that again is exercising our discretion. And in all of this, the legislature passed several years ago aggravating factors, firearms, sales to kids, all of those kinds of things. Take that out. We don't deal with that if the aggravating factors are present. But for a first-time person who possesses 70, 80 grams of marijuana, we're exercising our discretion to give diversion, to do something else. And I think this bill is a great start to the discussion about how can we graduate those penalties.
Very well, thank you, County Attorney Brown. Are there any questions? Representative Johnson and Representative Long.
Chair Mariani, County Attorney. I'm just wondering, instead of getting the grams so people can understand, especially those that are watching us on television, 70, 80 grams, how many joints would that be approximately?
County Attorney Brown, I suspect it has something to do with the size of the joint.
I would say thank you, Mr. Chair, but I'm not sure.
Mr. Chair, what I'm
So my
looking at the
law
average-
enforcement friends, Mr. Chair, my law enforcement friends have told me for the sandwich bag, so think of the 42.5 grams as a sandwich bag of marijuana. And depending on the person creating those joints, you're probably around 70. It's a fair amount of marijuana.
Representative Johnson.
Chair Mariani, County Attorney. I actually looked it up, and the average is about 43 or 0.43 grams per joint. 70 to 80 grams, you're looking at close to 150 to 200 marijuana joints. That's a lot. That's a lot of kids in school getting joints. We want to avoid that. So I do have some concerns. Do we need to look at maybe changing these numbers? Absolutely, but I think we have to look at the proper numbers.
Representative Dean.
Thank you, Mr. Chair, and I've been told never to do math out loud. But when I look at 42.5 grams and divide that by 0.43 grams, I come closer to 100, not 100 to 200. So just to be clear that, if we are looking at that, and granted, it's been a long time since I've rolled a joint. But it could be anywhere from really, really small to, I had the Cheech and Chong album when I was young too. So, your point is well taken, Representative Johnson, and I think the issue becomes the criminalization of it that we're talking about. And again, if we go for possession, if we go over 42.5 grams, it becomes a misdemeanor, and over 100 grams, that would then become a gross misdemeanor for possession. And when it comes to issues of sale, more than 42.5 grams will still be a felony.
Representative Johnson.
Chair Mariani, Representative Dean, the reason I picked that number is because the testifier had talked about 70 plus grams, so that's why I knew it was 97 otherwise.
Representative Long.
Thank you, Mr. Chair. Thank you, Representative Dean, for bringing this bill forward. I think it's long overdue that we take a serious look at our drug possession laws, in particular for marijuana. The city that you and I both represent, Minneapolis, there's been some good data on the racial disparities that come with arrests and other prosecution for pure possession. And the data that I've seen show that white and black people across the country use marijuana at basically the same rate. So you would expect that we would be seeing similar rates of enforcement, but that's not what we've seen. And ACLU did a study of Minneapolis numbers where they found that from 2004 to 2012, black residents in Minneapolis were 11 and a half times more likely to be arrested for marijuana possession than white residents. So to put that another way, in 2012, there were 193 arrests of white Minneapolis residents for marijuana possession and 1,326 arrests for black residents. So that's pretty dramatic when you understand that the rates of usage are the same. There was also just last year a sting operation that was stopped in part because once the data came out about, and these were stings for small amounts, which I think would probably fit under the categories that you have in your bill, Representative Dean. They stopped the sting because 46 out of 47 of the people who were arrested were black. So I think just these two snapshots illustrate the real problem that we have, and this is a broader problem than marijuana, but in racial bias in our enforcement of laws, but it really is played out, I think, in a more dramatic way in marijuana than just about anything else I'm familiar with. And I'm just curious, these two examples are pretty telling, but wondering if you know of other research or data on racial disparities that we see around the state or around the country or in Hennepin County in marijuana enforcement, and how this informed your bringing this bill forward, Representative Dean.
Well, Mr. Chair and
Representative Dean.
Representative Long, I believe the national average for the disparity between African-American use and white people use about 8 to 1. So this would tell me that we're actually doing worse than other states. And, you know, the issue of disparities is something that I think is really, really critical. As I've talked to friends around issues related to the full legalization of cannabis, I have some friends that tell me, wow, do you think that's really going to happen? And this isn't really flippant or joking, but to many of my white friends, I tell them, it's already legal for you because of the disparity of how an individual is treated when they have certain quantities. So this is actually trying to get to that point and trying to do away with the disparities that exist around our, our marijuana laws in the state of Minnesota, and also make them more uniform across the whole state as well.
Representative Long.
Mr. Chair, Representative Dean, the number I've seen for national disparities is 4 to 1 from black to white. So I think 11.5 to 1 we're considerably off track from even where 4 to 1 is not acceptable, but 11 to 1 is pretty outrageous. I'm curious if if you have any comments about what you've seen in Hennepin County as well.
County Attorney Brown.
Mr. Chair, Representative Long, obviously, disparity is something we're very concerned about in our office, and I think what you've seen in our guidelines, we typically won't charge the sale of under 5 grams, and for smaller amounts, we won't any longer send somebody to prison for possession of marijuana with typically not at all. And for the sale, it's really with approval of the division manager. What we're trying to get at is some of these disparities and how they're enforced, and by offering diversion more often, both pre-charge and once the case is charged, offering diversion to people. And as I think I explained at an earlier hearing on bail, also for people that successfully complete our diversion program, allowing an automatic expungement. We helped pass a bill several years ago that allows the prosecutor to move for expungement. So if you complete that diversion program, remain law-abiding for a year, then we can go ahead and ask the court to expunge that record without the defendant having to come through and do that, which can be an expensive and time-consuming process. So what I really appreciate about Representative Dean's bill is an attempt statewide with some uniformity to get at this so that it's not just individual prosecutors exercising their discretion, but we have some statewide agreement on what this graduated penalty can look like. Of course, prosecutors are always still going to be able, either city attorneys with the misdemeanors, gross misdemeanors, or the county attorneys in their felony role to offer diversion in cases, but I think this is a great start at getting at that disparity and trying to impose fairness.
Representative Long.
One more question, if I may, Mr. Chair. So I really commend Hennepin County Prosecutor's Office for taking these steps. I think they're much needed. I'm curious how much of an outlier you are in the state. Are other counties following suit?
County Attorney Brown.
Mr. Chair, Representative Long, I think what's not well understood, I think lots of prosecutors' offices do exercise their discretion to give diversion, to offer alternative dispositions. Obviously, we've got 87 county attorneys. There's a wide range of communities that they represent and a wide range of what that looks like. But as I said, we have a group getting together in the near future to talk about the numbers actually in Representative Dean's bill to see if we can come to some agreement on what those graduated penalties. So I think there's widespread agreement on graduated penalties, and now it's the hard work of what does that look like.
Thank you, Mr. Chair.
County Attorney Brown, any, not to press you, but any indication on when that statewide conversation among the county attorneys will take place?
Mr. Chair, before the end of the week. I mean, I think we understand this is something that has high interest. The MCAA board, a couple weeks ago, voted to support the concept of graduated penalties, and what they deferred was some conversation among a smaller group about what would those numbers look like, and talk about the numbers that are here in this bill. So,
Very, very helpful timetable for us. Representative Christensen.
Thank you, Mr. Chair, and thank you, both of you. Will you remind me what it was? Was it misdemeanor to felony before? Or no, I guess it would be no. You know, the penalties, there were two graduated steps, right? So the second one was felony. What was the first one?
County Attorney Brown.
Mr. Chair, Representative Christensen, two different things, possession and sale.
Okay.
So for possession, Minnesota has already decriminalized the possession of up to 42.5 grams. If you're caught with up to that, it's a petty misdemeanor, and it's punishable by a fine. No jail time, it's a fine.
Okay.
Any amount over that, it goes right to felony.
For
So
sale
that's
or possession?
just possession.
Just possession, okay.
Sale of any amount is a felony.
Okay,
So what I think Representative Dean's bill is getting at is in both of those instances, can we come to some agreement that it shouldn't go right from a decriminalized amount, a petty misdemeanor, to a felony? Can we find some rational graduation in those penalties, as we do in so many other areas, assaults and other things where we try and see, could there be something less than felony to start with?
okay.
Senator Christensen.
Thank you, Mr. Chair, and, you know, I think I support the bill. It looks like it should have been done a long time ago, I think, so thanks for bringing it forward.
Senator Johnson.
Chair Mariani, one thing that was just touched on briefly, and some concerns I've been hearing, especially from the law enforcement world, especially after they saw this bill, it's the issue of the concentrates. The difference between the high concentrated THC stuff and the leaf. And then you have fact, I believe it was in Colorado, they came up with a variety that is super high in THC. So if you have, let's say the 42 grams of leaf material, normal stuff we have here, just 2 grams of some of the concentrate is even stronger than that of THC than that 42 grams. So the question is, how are we going to work this out? Because sometimes it's not the weight that's the problem, it's the concentrate of it.
Representative.
Mr. Chair, this bill is neutral on the concentration, and, you know, we haven't addressed oils or resins or other types of things, because those do vary quite a bit. I understand what I think you're getting at, and that is, you know, if you have 42.5 grams of, I don't know, supercharged, we'll call it, that's a little bit different than just, you know, a smaller level of THC. But again, to add layers on this relative to the graduation around quantity, I think would become a little bit cumbersome. And then, of course, we're relying a lot on labs and their ability to take what would be typical marijuana and doing the analysis and really, really adding to that process. I mean, that's the way I think of it. I mean, county attorney might have a different opinion than what I have to say.
County Attorney Brown?
Mr. Chair, Representative Johnson, I think in my comments I said, the oils, the waxes, the resins, that's a conversation we need to have that does involve lots of other stakeholders. We have had some of those same problems, and frankly, right now, possession of any amount of the resinous form of marijuana is a felony. Because of those, I assume the legislature determined that was the reason for that. The challenge is that if you ask the BCA if an oil is the resinous form, they may not be able to answer that. They would have to know how it was processed. So how we define some of these terms is going to be important as well. But I think that's a conversation, again, it goes from possession of a zero amount, so a single gummy bear is a felony. I'm not sure that's where we need to start, but I don't think it's just the county attorneys that need to be part of that conversation. We want to have that with law enforcement, the community, the lab people, so that we're not passing a bill that we can't enforce because we can't test from our perspective. So the resins, the oils, the waxes, that's a different issue that we need to have a different conversation on.
Senator Johnson?
Chair Mariani, I agree, we need to have those conversations because they are important and they do affect our communities. But one thing I did see a lot of, in this bill, and a lot of talking today is about not charging offenses and changing the levels. I'm just wondering if this bill needs to go to judiciary.
Representative Johnson, the Chair of Judiciary and I meet on a weekly basis to review the bills, and we arrive at agreements in terms of you know, what the pathways are for these bills. I'll certainly take that possible suggestion into consideration as I discuss this with further with Chair Lesh. At this point, I don't think it needs to be there. You know, generally, don't hold us 100% to this, but generally, we're looking at judiciary in terms of procedures, you know, in courts. This is about changing a penalty, and so we feel that that's really more squarely, you know, within this committee. So it's a matter of just us being efficient, you know, with how we deliberate these bills. My guess is that at some point in this session, Chair Lesh's bill and my bill, rather, will probably be married way down the line. That offers other opportunities. But I'll certainly keep that in mind as I continue my weekly conversations with Chair Lesh. But at this point, I don't see a need for it to go to judiciary. And I'd certainly ask Chair Lesh to weigh in as well.
Well, Mr. Chair and Chair Johnson, you know, we talked about this when we saw the committee breakdown. One of my concerns was bills like this that you're talking about changing criminal penalties. Technically, every single one of them could come to judiciary. And that doesn't make a whole lot of sense to just be duplicative for the sake of being duplicative. So we tried to work out at the front end jurisdictional areas. There's still going to be some overlap. But in the interest of not just having repeated hearings for the sake of having them, we talked about this, we talked about others, and I don't think we need to see this for that reason, unless there was a nuanced procedural change, something is named in it that is inserting or removing like an affirmative defense, or something that would be applicable in the courtroom. Of course, this is a change in law, which means there's a change in jury instructions under the law, but I just think that is a duplicative interpretation, so that's why I said no.
Very well. We have questions from Representative Pinto, Representative Howard, and we just might be able to finish on time today. Representative Pinto.
Thank you, Mr. Chair. I'll try to be quick. As members know from other debates we've had, it's important to me how proposals to change penalties kind of fit into the broader structure of our criminal laws. And so I think this is terrific, and I really thank Representative Dean for his leadership on this, and the Hennepin County Attorney's Office, and County Attorney Freeman, and County Attorney Brown. And I guess I just want to maybe have County Attorney Brown comment on this, and how this, so it seems to me we made the changes to the sentencing guidelines, to the statute a couple years ago, to say that possession of a small amount of some other narcotics was, rather than, being a felony, was a gross misdemeanor. And I guess this, members, seems to me to be a really straightforward, simply applying the same principle, that rather than jumping from a petty misdemeanor to a felony, we have a series of steps, just like we do really with other drugs. And I've certainly found this as a prosecutor. So I wonder if County Attorney Brown could comment on the kind of the comparison with the change that was made a couple years ago in that way.
County Attorney Brown.
Mr. Chair, Representative Pinto, I believe this was as a part of the initial discussions in that bill that was done 2 years ago. Having been part of those discussions, I think it became clear that was going to be too much, and so this concept was taken out. But it's been something. There was a controlled substance work group through the legislature way back 2011, where these kinds of graduated penalties were first talked about, thought about. So I think it is a natural extension of the work that was done 2 years ago. And that saw a very big group of stakeholders come together on agreement for some changes, important changes to the controlled substance laws, and I would hope for a similar result here. And I know the Ramsey County Attorney's Office has adopted, they've exercised their discretion as well. County Attorney Choi has implemented some changes to how they handle marijuana cases. So this is something that we've been talking about for a while, and that fits into that notion.
Thank you. And so then one final,
Representative.
thank you, Mr. Chair. And so, because I know that there are broader discussions about legalization of adult personal use of cannabis, and I know Representative Dean's been a great leader on that. But in the meantime, at the very least, having these graduated penalties to have the scheme make sense, so that the difference between 42.4 and 42.6 doesn't jump from petty misdemeanor to a felony. Boy, that makes great sense. So thank you again to both of you. Thank you, Mr. Chair.
Representative Howard.
Thank you, Mr. Chair. And I had a comment or a question kind of along those lines of Representative Pinto, that I really view this as a supportive bill when we look at the scheme of our legislation around these issues that span back many, many decades. And I'm wondering if the author would comment on the historical context here in terms of the significant mass incarceration rates we've seen, dating back to the 70s and 80s, and how you see this bill fitting in to the overall discussion, and really the impact on the community, and also really the state budget as we look at what our laws have done in this zone over the course of, many decades.
Sure.
Representative Dean.
Mr. Chair and Representative Howard, we can just chart almost directly the relationship between the war on drugs and the number of people that have been increased incarceration in the state of Minnesota. We know that when it comes to sale and possession of marijuana, that as Representative Long said, disproportionately has been impacting people of color. And when you look at our prison population in the state of Minnesota, it's disproportional, the number of people that are incarcerated that are people of color relative to the population. So, I mean, in some ways, this is a remedy that's been long overdue. But I also know that that the cost to our system has become unbearable I had the good fortune of going to a conference in San Diego where I heard Grover Norquist speak, an individual who you might not think was in favor of reducing penalties and encouraging individuals to lead a different life, and so that they're less likely to recidivate. And the reason is the cost of getting individuals back on track in what a lot of us would consider a good full life is a lot less expensive than locking a person up. In the state of Texas, they were looking at the trajectory of their incarceration. And I think it was within the next 10 to 15 years, they were going to have to build 2 new prisons at a cost of over, I think it was, each one was over $350 million to taxpayers. Well, when you're looking at having to increase taxes to lock people up, I think a lot of people start to pay attention. And this has made a lot of these issues less partisan than they have been in the past. So I think, the place we've gotten to, unfortunately, has had a lot of casualties along the way. But now that we're here, I'm really excited that people are starting to understand how we need to address these issues. And also when it comes to, drug use and alcohol use, that a lot of times this is a public health issue, not just a criminal justice issue. So I'll end it there, Mr. Chair. I can't see a clock, so I have no idea what time it is.
You're doing wonderful. Representative Howard?
Thank you, Mr. Chair. Thank you.
Thank you. Is there anyone else that wishes to testify in this bill? We have 2-3 minutes. You can come forward. We only have 2 minutes. Please state your name for the record and give us your quick testimony.
I'll stick to it. I won't read any notes. Thank you, Mr. Chair and committee members. My name is Marcus Harkis. I'm the Executive Director of the Minnesota Campaign for Full Legalization. We represent over 500,000 adult cannabis consumers in Minnesota and the nearly 10,000 Minnesotans who are criminalized each year. I'm here to testify in favor of this bill. I truly believe that it shouldn't be criminalized for any amount because it's a healing plant, it's not a crime. But this will go a long way to sparing lives from the ruins that being criminalized over this plant causes them. The most dangerous thing about cannabis is getting caught with it by the police, because you could lose your freedom, lose your job, lose your housing, lose your children and more over something that makes people feel better and has never killed anyone. So I would ask the committee to pass this bill and thank Representative Dean for introducing it. But the bottom line is prohibition is the problem, it's not cannabis. And full legalization is really the only solution. So thank you for the time.
Thank you, Mr. Harkis. Next testifier. We're down to about a minute.
Mr. Chair, members of the committee, Brandon Borges, I'm the chair of Sensible Change Minnesota. I'm the policy arm of our volunteer-based nonprofit, Sensible Minnesota. I'm also an attorney. I practice in criminal law and some family law. Since 2015, Sensible Minnesota has worked with around 500 patients. The reason we're talking with you today is that in Minnesota, we have legalized oil and concentrate for patients to get access to our medical cannabis system. Now, we've also been successful in petitioning the Commissioner of Health for the inclusion of PTSD, autism, and Alzheimer's disease. Back in 2014, when this law was first passed, the medical cannabis law, it was estimated that around 30,000 patients would be helped. But today, that number is sitting around 15,000 registered patients. Those people are still out there, and they're still using cannabis. And they're choosing, by and large, from what we can tell from our patient groups, to use concentrated cannabis products because it's not something that they smoke, and many people stay away from that. As of February 28th, there were 15,331 patients currently enrolled in the program, and over 7,000 of those who were once registered but either dropped their enrollment, either due to the high cost, or they passed away. According to the January 2019 Medical Cannabis Program update, Fewer than 11,000 of the Minnesotans' nearly 15,000 registered patients have made a purchase from a registered state manufacturer. So the reason I'm talking about this today is that patients in Minnesota have to pay quite a bit more to access what I would like to see potentially included in this bill as an amendment at some point, which is concentrates. And in Illinois and Arizona, on adult use markets in Oregon, for example, that same medicine is available for less than 10 cents per milligram, where we're paying around 18 to 24 cents per milligram in Minnesota. So it's a very substantial cost difference. As the criminal defense attorney, I get contact from patients that call our firm and ask us to represent them in cases where they brought these concentrates from other states because they can't afford them here. And if they happen to transport them in Minnesota, they happen to have over $100 of concentrate in their vehicle. That's registered under Minnesota state law as a conveyance device, and they can kiss their vehicle goodbye as well. So,
Mr. Borges, I'm going to ask you to wrap it up.
yep, that's exactly it. While I do appreciate and understand as a defense attorney and as a representative of this organization that this bill is going in the right direction, we would definitely like to see incorporated into the amendments, and we'll have discussions, of course, with the other county attorneys associations involved to try to get protections for our patients, because we need to put our patients first. These are sick people in Minnesota. So thank you, Mr. Chair, members of the committee. I appreciate your time.
Thank you, Mr. Borges. I want to thank everyone for, please, there should be no demonstrations in a committee hearing here. I want to thank everyone for the questioning, for the discussion, for the testimony here today. I thought it was a very rich session. I certainly walked out of here learning quite a bit more. Representative Dean, I'll have you last word, and then we'll move to lay the bill over.
Sure. Thank you, Mr. Chair. Thank you, committee members. I appreciate your support.
Very well. With that, the chair lays over House File 2013 for possible inclusion in the omnibus bill.